A very good evening to honor present. On behalf of Study Circle, I welcome you all to the 98th meeting. Today's topic is on wills demystified, and the resource person of the day is Mr. P.B. Balaji, Advocate in Madras High Court. I now welcome Mr. Om Prakash, Senior Advocate in the Madras High Court, to give the welcome address and a brief introduction of the speaker.
Good evening, everyone. It is very nice to meet you all after a long time. We are here for the 98th webinar of the study circle. This group study circle had been a great source for us to keep in touch over the period of pandemic. And we ensure that whatever knowledge sharing which had happened will continue in terms of regular webinars, at least monthly ones. In the said series of webinars, today we have a very interesting topic on wills demystified. We also have a very interesting speaker, Mr. P.B. Balaji, Advocate, Madras High Court. To the members of the bar at Madras, it doesn't require a big introduction about the speaker of the day. But in any case, as a person being assigned with the task of introducing the speaker, I take this opportunity on behalf of all the members of Study Circle at the first instance to extend a very warm welcome and invitation to Mr. P.B. Balaji. He had agreed to conduct this session after we reached out to him, and it is a pleasure to have him on a very interesting topic. As you all aware, Mr. Balaji had been practicing in the Madras High Court. We know the lineage which he carries in terms of the profession. Persons who had been on the practice of Madras High Court as well as the civil courts cannot express any doubts about knowing the person. We were all introduced to this profession in the civil courts when we had seen the huge bundles and cases being handled by his office, primarily by Mr. P.B. Ramanujam, who had been a fatherly figure for many of the juniors in the bar. And the same thing is being followed by Mr. P.B. Balaji. When we see about some persons over a period of time, we really enjoy the growth which we have seen. We really feel very proud of the person. In the same sense, I would also like to point out that today you have Mr. P.B. Balaji as a very outstanding advocate. He is a prolific author. He has brought out some very good books. We had at the first instance a great commentary on the Tamil Nadu Rent Control Act by Mr. P.B. Ramanujam sir. And the same legacy was followed by Mr. P.B. Balaji when he authored the revised edition of the said rent control enactment. And over the period, he has now authored 2 more books. When we speak about the law books, commentaries which are being authored, you have categories where people who are more towards academics and who have been expressing their wish of bringing out more books. You have the other people who are getting into the profession very seriously, and as you grow over a period of time, the profession in fact takes you fully into it. You don't find time to spend for any other ovation. So therefore, you will have 2 categories. You have a very serious practitioner who will not find time to spend on academics. You have people who have authored books on various law subjects whom you don't find on the practice side much. On the contrary, we have Mr. P.B. Balaji, who had been very busy handling lot of litigations, very busy handling his office, which had lots of briefs. At the same time, he was very much towards the academics, spreading out the message as well as the thought process. In that category, he had brought out 2 books during this pandemic. One on the law of wills, a handbook, and the other one was law of intestate succession. Both books had been very useful to the members at bar. Today we are also going to hear him on the same subject in which he had authored a book. On behalf of the members, I extend a very warm welcome to Mr. B. Balaji once again. I also invite all the members who have joined for the session, and we also look forward for many of these sessions in the coming months. With these few words, I now invite Mr. P.B. Balaji to enlighten us on the subject for the day. Thank you.
Very good evening to one and all. Thank you, Mr. Om Prakash sir. It's a great privilege to get such huge compliments from a senior advocate like Om Prakash, whom I have very great respect for. And I'll have to admit, lockdowns have helped me write the books. So I would not concede what Mr. Om Prakash said. I balance both. During the peak lockdowns, we literally had no work. So I took up to writing. And I should also mention, this is not the first time I'm addressing a lecture in the study circle. There was an earlier occasion where I spoke about the amendments to the Specific Relief Act. But that helped me, that session, I should admit, helped me when I wrote the book on law of specific performance, which was the first book during the first lockdown. Then came the other two books and the new book on the Rent Act. But the discussions and the questions and doubts that were discussed and deliberated during the last study circle, when I spoke, immensely helped me when I wrote the book on the law of specific performance. So it's been really great honor to come back and address the members of study law circle. And I think today's topic, as Mr. Om Prakash said, is a very, very interesting topic. I won't agree with the second part, not an interesting speaker, but definitely topic is very interesting. We all know what is a will. As lawyers, we will definitely know what a will. Let us see what the Succession Act talks about a will. A will is merely a declaration of a person as to how his properties or estate should go after his lifetime. So his intentions or wishes to be carried out after his lifetime in the form of a legal declaration is called a will. Section 2H of the Indian Succession Act defines what a will is. In fact, a will is a very, very simple document where you can easily commit mistakes because law has developed so much. The earliest legislation was the Hindu Wills Act of 1870, which concerned the law of wills. It was repealed later when the Indian Succession Act 1925 came into force. Then we had the Indian Succession Act of 1865, which applied to the Europeans because we did not get independence by then. The Parsis and Europeans, the Christians were governed by the Indian Succession Act of 1865. That was replaced in 1925, which is the current act, Act 39 of 1925, Indian Succession Act, which came into force in 1927. So therefore, this is the history of the law of succession in India. It started in 1865, and we had the Probate and Administration Acts, which were in force for a brief period, subsequently repealed in 1925. So all the earlier acts like the Hindu Wills Act, the Indian Succession Act of 1865, the Probate and Administration Act of 1861 and 1868, all of them were repealed, and one consolidated enactment of 1925 came into force. This Succession Act deals with interstate succession of Christians and Parsis also. But today the topic being wills, we are concerned with Part 6 to Part 9 of the Succession Act, which deals with testamentary succession. So Part 6 to Part 9 deal with succession the wills, and Part 10 is dealing with succession certificates. Again, succession certificate does not come within the domain of wills. Therefore, technically speaking, it is only Part 6 to Part 9 which deal with testamentary dispositions and wills, about which I am going to take you through. So as we all know, a will comes into effect after the lifetime of the person who makes it. So that makes it even more interesting or important that the person who writes the document is not alive to speak about the document. So what goes into proof of the will? So that is what the courts have been coming across day in and day out. In fact, will cases are very interesting. I have conducted a lot of trial cases of testamentary OPs, converted suits, where law is really very interesting, and you have scope for very enjoyable trial. So that you have very good ground for enjoying trial in will cases. So what we know about wills is there are several types of wills. Major category which we see is two categories of wills: privileged wills and unprivileged wills. Privileged wills are wills which are available only to persons engaged in warfare or the mariner at sea, and the person who is actually fighting the war for the country. These, for example, a soldier who is fighting, let us say, a soldier who was fighting the Chinese army in the Indo-China war in the 1970s, was about to die. He had the fear of death gripping in him. He sees the enemy aiming at him and he's going to shoot at him. At that time, he has no time to go search for a paper or a pen and write down his will. Therefore, there is a privilege given to such persons. They can execute a privilege will. It can be an oral will. Privilege will is basically an oral will. He can set out, he can dictate his will to a nearby soldier or a person who is near him. He can record it, that last sentence, which last wish of the soldier is a privileged will. But there are conditions again. If he survives for a particular period of, say, 1 month after the oral will, that oral will terminates. It does not have effect. So these are which conditions which you have for privileged wills. This is very uncommon. We don't see much of privileged wills in the country. There are absolutely nil trial cases, if you ask me. If you look for citations for privileged wills, you won't get any. When it comes to unprivileged wills, which what we are concerned, the common man, with unprivileged wills, this is set out in section 63. What is the requirement of an unprivileged will? It has to be in writing. Unlike a privileged will, an unprivileged will has to be in writing. It has to be attested by at least 2 witnesses. There can be 3 witnesses, there can be 4 witnesses, but at least 2 witnesses. And the testator must sign the will or make his mark on the will. Suppose he has a rubber stamp. He can affix his rubber stamp without signing, but it should be in the presence of 2 witnesses. Here again, section 63 is very interesting. You read section 63, it is not necessary that both the witnesses should be available at the same time. But there is one condition for this. For example, I write a will in the morning. I have attesting witness X with me. He sees me sign the will. I cannot sign the will second time. But minimum requirement is 2 witnesses. Therefore, I call Y later in the day. Evening, Y, second attesting witness comes. I must tell Y that, Mr. Y, this is my last will. I have signed this in the morning in the presence of X. I want you to be the attesting witness. So there is a direction from the testator to the second attesting witness who has not witnessed the execution. This is permissible. So this is also one of the allowances which section 63 makes. So these are the conditions which, very simple, the will doesn't require stamp paper. It does not require registration. Well, what are the pros and cons of registration? I'll come to it a little later. Therefore, first, no form. There is no form. Actually, a person need not even go to a lawyer to write a will. In fact, I come across a very funny will where a person, a very wealthy man, he wrote a will and everybody was anxious to know what he had written in his will and whom to bequeath because he was a bachelor. So the will was opened in the presence of his friends and distant relatives because he did not marry and there is no class 1 or class 2 legal heirs. And it was a very short and sweet will. He said, being of sound mind, I spent all my money. This is the shortest will which I have come across. So jokes apart, the real reason for writing a will is to alter the line of succession. So there are a lot of people who come to me and ask, I want to give my children equally. There is no reason or no purpose served in writing a will in such cases. When do you write a will? This is a common question, burning question, which a lot of common people come to advocates and ask, should I write a will? The question is, if there is going to be a disruption in the line of succession, the ordinary line of succession or the law of succession, then alone a will is required. For example, there are 2 sons, son X and son Y. The son Y is an outlaw. The father does not want to give the property to Y. Instead, he wants to give it only to X. If he does not write a will, the property will go 50-50. Being class 1 legal heirs, 2 sons X and Y, subject to no other legal heirs, they will get 50-50. So this father wants the son Y not to get any share. Then you advise him to write a will. So, and it is always advisable to give reasons for why you are not bequeathing a person who is normally entitled to your estate or a share in your estate. Because the concept of suspicious circumstances, which again we will discuss a little later, has evolved over a period of years and decades. And this is today primarily playing a very, very vital role when it comes to proof of will in courts. As we already said, the person who writes the will makes a solemn wish, that person dies. He is not available to testify that this is my will. I wrote it out of sound mind when I was in sound mind and disposing state of mind, memory, and understanding. I complied with the execution process by signing it in the presence of two witnesses. I am not going, the testator, the maker is not alive. So therefore, it's more incumbent on the courts who are deciding the matter to see whether execution was due and proper as required under the law. It's a very famous phraseology which the Supreme Court framed. Court should sit in the armchair of the testator and decide. So when they are confronted with a will or a doubt with regard to the interpretation of the will, you please place yourself in the armchair of the testator. Think you're the testator. What would you have done in such circumstances? Whether in such circumstances the bequest is valid, is reasonable or not. The bequest may be unreasonable, but there are reasons which the testator may have to disinherit somebody. Another funny incident was one funny will where a person has two sons. His wife is alive. He writes a will saying that I give my 50% property to my wife, who has taken care of me all these years and has been very loyal to me. Then he gives 25% to his elder son. Balance 25%, he gives it to charity. He disinherits his second son totally. But in the will he writes, and I'm sure my second son, why is eagerly waiting to know what I've left for him. He's never been happy with me, and I'm just saying a hi to my second son. So this is another, it is a very funny reason, but at least a reason is given for disinheriting a person. Here again, it will boil down to due execution. The second son will have a right to contest or challenge the will on various grounds available to him. Then coming back to the origin of wills and what are the different types of wills. There are different types of wills. Very interesting and I would say most reliable form of will is a holograph will. It is also called a oleograph will. A holograph will is a will which is entirely written in the handwriting of the testator. So, which means the pen follows the mind. Therefore, more weightage is given by the courts to such holograph wills. Then we have already seen privileged and unprivileged wills. These will all come under unprivileged. Again, you must remember that even soldiers or a mariner at sea can make an unprivileged will. There is no bar. Only where he is not in a position to make an unprivileged will, there is a special privilege given to him. And the other types of wills are a conditional will or a contingent will, where the will say this will come into effect only on the happening of a particular condition. If the condition does not happen, then the will dies. There is no will. It does not amount to a will at all. It cannot be taken for administration or for probate. Then we have joint wills, or it's called joint wills. Joint wills are where two persons make a joint will, husband and wife. They may be owning different properties, but they can come together and write a joint will. But interestingly, as we all know, a will is an ordinary piece of paper till the person is alive. The moment he dies, it takes a legal effect of the form of a will. Otherwise, it has no value. It is, I can throw that paper into a dustbin, make another will tomorrow. So as long as I am alive, I can make any number of wills. The last will alone prevail. Therefore, in the case of joint wills, assuming the husband and wife make a joint will, whether the survivor, suppose the husband dies first, the survivor wife, interestingly, can she revoke the will? Can she modify and change the will? Is a very interesting question. What the courts have evolved is, there is no clear-cut judgments on this point, but what I could see was the courts have evolved a theory where if the survivor had taken benefit under the joint will, then she cannot alter the will. Therefore, it ceases to be a joint will if the survivor takes benefit under the joint will. But suppose she does not take benefit, she is entitled to alter and make a fresh will for her share of the property. And the person who dies, his will can be probated even though the survivor is alive. Then we have mutual wills. There are two persons, I give to X, X gives the property to me. This is called a mutual will. Then we have international wills. India is not a party to the Convention of International Wills, and therefore, but for academic reasons, what it says is a will can be written anywhere in the world in respect of any property anywhere in the world. So it doesn't require a domicile. So this is the concept of international wills, which India is yet to adopt. Very, very interesting development is living wills. We have come to know that countries like the United States of America and other countries, their concept of living trusts are made, where a person writes a will. It's called a living trust abroad. We call it a living will. It is mainly for medical reasons. A person who probably goes into coma, he anticipates that I may go into coma 5 years down the line. So he can set out what treatment should be given to him or whether treatment should be refused by way of a living will. This concept was very alien to Indian law until 2011, when the Supreme Court had an occasion to deal with one of living wills, where they laid down about 6 conditions how a living will should be given effect to. Because the person is alive and you want to refuse treatment and give him, like it's just euthanasia. Therefore, whether person should be refused medical treatment and allow him to die was the question which came up before the Supreme Court in 2011. But later in 2018, in a common causes case, a larger bench went into the concept of living will and is reported in 2018, 5 SEC page 1, where the Supreme Court set out about more than 20 guidelines. So it's not very easy to follow. It's not, therefore, till today, I would say making a living will in India is practically impossible, because the process starts with a normal will, how a sound person of sound mind can make a will. Then he has to choose a person who will give consent for the living will to be given effect to in the event of the testator being unable by slipping into coma or some other health condition that he is not able to give consent. Then that copy of that will be lodged with the magistrate. Magistrate will hand over a copy to the local government and the family physician, and all relatives who will be entitled to a share in the will be made known about the living will. So all these are practically, if you ask me, it's very impossible. Then what happens after it? Then you approach the collector, and in the presence of all family members, if there is no disharmony, it will be allowed to die. Suppose somebody contests, saying this, no, one of the daughters says, no, I don't agree to this. Then there's a medical board consisting of 3 doctors from various fields. These 3 doctors will examine the patient and give a certificate. That certificate will be taken into account by the district court, and it will be given effect to if there's no problem. If suppose the district court refuses, a 226 writ petition is maintainable to a division bench of the Madras, the concerned high court. This is a very complicated process. Assuming that the person is alive in the hospital, you want to undergo all this, is going to take a lot of time. Given what the procedure, we know what happens to the government and approaching the court and getting an order. It's not going to happen overnight. It's definitely going to take time. There are people who will put spokes. People who are having some interest may not, or definitely close family members, blood relatives will not allow the person to die. Even though the person has chosen to refuse treatment, they would try to say, it doesn't matter, we'll spend and see what best can happen. Therefore, I practically see we are still a long way off from giving effect to living wills. This is so far as living wills. The most common is regular wills, the unprivileged wills the person makes. As I said, registration is not mandatory. In fact, as early as in 1930s, the Privy Council said, merely because a will is registered, it is now sanctity when it comes to proof of due execution. So therefore, what is most important is due execution of the will and proof. The only persons who are available or who may be available are the attesting witnesses. Therefore, burden is very heavy on the propounder. The propounder is the person who puts forth the will in the court, who wants to propound the will. He propounds the will in the court of law. Therefore, he is called a propounder. The propounder can be an executor or a beneficiary. So where the will names an executor, then alone probate is granted. Where the will does not name an executor, but gives various benefits under the will to persons A, B, C, D, one of them or all of them or some of them can approach the court and seek letters of administration with the will. So therefore, this is the primary difference between probate and letters of administration. Probate is where the will names an executor. Letters of administration is where there is a will, but no executor is named. So it is incumbent on the beneficiary to approach the court and propound the will. Then there is also a category of letters of administration without will. So for academic purpose, I will also say that succession certificate is where properties are only movable properties. Then you approach the court and seek a succession certificate. Suppose a person dies without a will, but he has immovable properties and movable properties, then you approach the court, either the district court or the high court, and seek for letters of administration without the will. So these are the different categories of petitions which are available to be filed before the district court or the high court. The district court and high court have concurrent jurisdiction, but in where the high court is there, for example, let us take Madras. The Madras, even though district court has got concurrent jurisdiction, it is the high court which can be approached. Section 300 of the Indian Succession Act. So therefore, these are the basic procedures which one has to follow. The form, what form of a petition should be filed. Coming to registration, as I said, there is no sanctity of registering a will. The advantages of registering will are, suppose the original is lost, you can go back to the registrar and get a certified copy. You can get probate on a lost will, on a destroyed will, provided burden of proof is very heavy. There are provisions in the Indian Succession Act where even a lost will, contents are not known. If circumstances are made out, you can still be entitled to a probate, and it will be limited till such time the lost will is found. And the burden is on the propounder, and probably the court will cast a very, probably I would say, bond, require a very hefty bond from the propounder, because they are believing the version of the propounder that there has been a will and the original is lost. So the copy is available, certified copy is available. It makes things very simple. Therefore, that is one big advantage of registering a will. The minus points of registering a will are, suppose X writes a will at the age of 75. He is hale and healthy. He registers the will. 15 years later, family circumstances change. He wants to alter the will drastically, but he is unable to go to the sub-registrar's office. Let us say he moves abroad with his son. So he is not in a position to come over to India or Madras and register subsequent will. That will be taken advantage of by the disinherited legal heirs. They will cast a suspicion saying that he registered the will originally, but second will is unregistered, therefore doubt it. This is a suspicious circumstance which is very, very commonly raised by caveators or the persons who are challenging the will. So therefore, this is a flip side of registration. There are very interesting provisions under the Registration Act where a will can be registered even after the demise of the testator. Sections 40 and 41 of the Indian Registration Act. Very, very uncommon. Most lawyers may not know this provision. A testator during his lifetime can go and lodge his will with the registrar. Section 35 of Registration Act, there is no problem. I am admitting execution of my will, registrar will admit, finish the registration over. Suppose after the demise, the legatees feel the disinherited, disgruntled son may destroy the will. It is an unregistered will. The will is destroyed, I will not be able to prove the will in the court. Therefore, I rush to the sub-registrar and lodge and invoke sections 40 and 41 and register the will. There are certain conditions which you will have to comply with. You will have to prove that the person who wrote the will was the testator. He is no more. And I am entitled to lodge the will. I must be either an executor or a beneficiary. Only these persons can lodge a will after the death of the testator. So this is a very interesting provision which you can remember. Advise parties, 40 and 41 of the Registration Act, very not commonly followed. But the provision available which you can do lodge it. And it will be opened after once the death certificate is shown. And the beneficiary wants a copy, the seal will be opened, a copy will be given to you under the subsequent provisions of the Registration Act. It will be resealed and lodged back with the sub-registrar until the court calls for it. This 40 and 41 is very interesting. Otherwise, there is no really benefit, I would say, advantage arising, accruing from registering will. Because time and again, right from 1930 up to 2021, the Supreme Court has time and again reiterated that merely because the will is registered, it doesn't mean the will is duly executed. Registration is a totally different aspect. Execution is when you execute the will. You may not have executed the will at the sub-registrar's office also. You may take it a month later to the sub-registrar's office and register it. Therefore, the courts don't attach much sanctity. Is one of the factors. One of the factors to prove that there is some authenticity, some genuineness. It may help where there is a dispute with regard to the date. Suppose the will is registered. Suppose there is a rival claim that there is a will earlier made or later made. Then if the will is registered, it gives an added advantage because definitely it has to be registered on that particular day. Therefore, the date of will is so and so date, so and so month, so and so year. So that will help the court to find out whether this is the last will and testament. So again, here, last will and testament is very important because my last wish is what is very important. I may have wished something earlier 2 years back, but today I change my mind. That is the wonderful feature, characteristic of a will. It is ambulatory in nature. I can keep changing my will. Another very unique feature of a will, which you can never find in any other kind of document, is I can include future properties. I may not be owner of property, a flat in the next street. I may be intending to acquire. I can still write in my will that I am proposing to buy an apartment in the residential area where I reside, the same area in the same locality. I bequeath that flat also to my son or to my daughter. That bequest is valid. In no other document, you can't make a sale deed. You can't, it's not a transfer of property. You cannot transfer a property which is a future acquisition. So no other document, a sale deed, settlement deed, release deed, name it, you cannot do it. The very unique feature is inclusion of future properties in a will. And it is revocable. The other advantage is it is revocable. Suppose you want to change your mind, you make a particular line of charity or bequest. You're not happy with the charitable organization. They're misusing funds. So you can change your will. So your last will prevail. So it is therefore the last will and testament which will prevail. And another very interesting aspect has always been whether will and settlements. What is the difference? Why not write a settlement deed? Why should I write a will? Or why should I do a settlement deed? Why not write a will? This is a burning question. A lot of clients come up with. We'll have to keep one. There is no cost for registering a will. It's only the nominal registration charges you pay. No stamp paper is required. It can be an ordinary A4 paper or green sheet or a blue sheet, whatever the testator desires. The only requirement, as we already saw, was it should be signed or mark of the testator affixed in the presence of two witnesses who may need not be present at the same time. That also we have seen. So therefore, simplicity of writing a will as against the complexity of writing a document. Definitely for a settlement deed, you will have to go to a lawyer. A preamble should be set out. Now the procedure is even more complicated. You will have to upload the document. So all these problems in a will, because will does not require registration. The process for writing a will is very simple, and it can be in any language, any form. If I choose to write it in Tamil, it can be in Tamil. Not necessarily it should be in English. It can be in my mother tongue. Whatever language I use, it's not like a sale deed or settlement deed where I have to, certain important clauses have to be there. Acceptance of the gift or the inclusion of legal heirs, administrators, and the actual transfer, settlement that's hereby settled in favor of so and so, and it takes effect. I have no right to revoke. So all these are which you definitely have to go to a lawyer. But for a will, you can make it at home. If you know the basic principles, this is what is needed for a valid will. You can make it at home in the presence of two witnesses. Therefore, it is the simplicity of making a will. But coming to settlement, see, will, as we said, I already said, it's a piece of paper until the testator dies. The moment testator dies, it assumes the legal character of a will. But a settlement is a transfer of property during the lifetime of the maker. So therefore, he cannot postpone under a settlement deed the alienation of the property or the property sitting in the hands of the beneficiary. See, suppose father settles the property to his son. He divests himself of the entire title, right, and interest in the property. That is a settlement. It is instant. Transfer of title is immediate under a settlement deed. Whereas under a will, it is postponed. It comes into effect only the moment the testator dies. Therefore, this is one very important feature of the distinction between a will and a settlement. The settlement should be registered, will need not be registered. And now there have been a lot of cases, confusion arose in number of cases where, though it was styled as a settlement deed, it had the characteristics of a will. So whether person can say this settlement will come into effect after my lifetime. The disposition will come into effect after my lifetime. I reserve my right to cancel the settlement deed. So even though he had worded it, the nomenclature is a settlement deed, the courts have consistently held it is only a will. It is a glorified will. You may have paid 25,000 rupees stamp paper, registered the will in the sub-registrar's, the settlement deed in the sub-registrar's office. No, it is only a glorified will because it does not transfer the vest property instantaneously in the basically. Therefore, you cannot do that under a settlement. You may call it a settlement deed, it is only a will. Now, after, in fact, 2004, the law developed further. There are cases where I transfer the right instantly, but I reserve a right of residence or a right to collect income from the property in my lifetime. This issue cropped up. Madras High Court as well as the Honorable Supreme Court in a number of cases have held that consistently this restricted right of reservation of right to reside in the property or right of collection of rental income is permissible because the title is divested immediately under the document. The settlement deed should clearly say it is irrevocable. If the settlement deed says I reserve my right to revoke the settlement deed, then it becomes a will. But otherwise, if he is transferring the property to the son instantly, gives him right to have mutation of records, hands over documents, but only has a limited right of residence, right to reside in the property during his lifetime or collect rental income from the property. This is permissible. The courts have also now approved of such settlement deeds. Therefore, this kind of settlement deed is probably an extension to a will. But still, it is only a settlement deed which can be validly executed, registered, and acted upon. This is the difference between will and a settlement. Then coming to due execution, as I said, what is required of a person to prove a will? See, as we all know, there are presidency towns, Bombay, Madras, and Calcutta. The Succession Act came into force in 1927. We were still under the British regime. So those times there were three major ports through which the Britishers had access into the country. They were Madras, Bombay, and Calcutta, the major ports. Therefore, this is a place where they set up high courts, convenient to them. They did not choose Delhi or Hyderabad. So they chose ports which were convenient to access, to reach from London, from Europe. These are called chartered high courts. We all know. We all have privilege of practicing in the chartered high court at Madras. The chartered high courts, there is a special law, Section 57. So Section 57 deals, or the Succession Act mandates that two conditions. One, if the will is executed within the territorial limits of any of these presidency towns, the Calcutta, Madras, and Bombay, then it requires to be probated or letters of administration. This is the first condition. Second condition is if the will includes property in which is situated in any of these three presidency towns, then also probate is required. So very simple. An example I will give. A person writes a will in Madras. Property may be in Madras, may not be in Madras. Will has to be probated because of the mandate of Section 57. For example, a person writes a will in Bangalore. Property is situated within the territorial limits of the Madras High Court. Then also will requires probate. That is the mandate of Section 57. Section 211 of the Succession Act vests the property with the executor or the administrator. See, as we all saw, who is the executor? Executor is the person who the will, the testator himself names, he has confidence in the executor. So suppose my father has confidence in me, he will name me executor and say that I will direct the executor to carry out my wishes. Because he has confidence in me, he names me as the executor. There can be one executor, there can be joint executors, there can be a sole executor. Suppose that there are two executors, we have to see the language of the will, whether jointly and severally is it possible, or if it is just and X and Y are the executors. Then both of them have to come to court. X alone cannot come to court and say, give me probate. Because the will is very clear, because you're sitting in the armchair of the testator. When I say and X and Y, we say they can come jointly or individually, then I permit X or Y to come and get probate of the will. That is where the execution of the naming of the executor under will. This is 57. 211 vests the property with the administrator or the executor. Administrator is the person who can propound the will, being a beneficiary. Nobody else can be an administrator. I must have some interest or bequest in my favor under the will. Only then alone I can seek administration of the will of the deceased. Executor, there is no problem. My name is already imprinted in the will to execute the will. Can an executor renounce? Yes. if the executor is not interested, he's a very busy person, or he had left the country, so he can renounce and say, please, I don't want to execute, I'm not going to act as executor, therefore you please go ahead. And then what happens? The beneficiary alone can approach the court and seek for letters. He will not get probate. He will get only letters of administration. Similarly, suppose, let us take a case where a probate petition is filed by the executor. Pending the probate proceedings, the executor dies. In some cases, I have strangely seen the legal representatives of the executor are sought to be brought on record. It is not correct. You can't do it. The executor is an office by itself. It is not going to pass by succession. So therefore, in such cases, an administrator, that is the beneficiary, any one of the beneficiaries, can approach the court and seek amendment of the probate and substitute his name in the place of the executor and seek for letters of administration. The Calcutta view was totally different. They said you can't substitute. The probate petition has to be dismissed. And I think Bombay High Court said, Bombay High Court. Then the probate petition has to be dismissed. He has to file a separate application for letters of administration. But recently the Supreme Court said, no, doesn't matter. No prejudice is caused. All of them are already before the court. No harm in allowing amendment and substitution is the latest view of the Honorable Supreme Court. Therefore, pending probate proceedings, if an executor dies, the beneficiary can seek substitution and come on record. This Madras High Court is permitting this practice, and Supreme Court has approved of it also. So this is again with regard to filing of the petition. Normally, lawyers probably who enrolled during my time will know. So easy to get a probate. We only used to stand up and say all formalities complied. Judge will say probate granted. Items 1 to 10 in 5 seconds list will be over. Next item, 11th item, motion cases will go on. But now with a lot of, I would say, a doubt which the judiciary has probably because of litigants and unscrupulous elements who try to take advantage of the fact that the testator is no more and create fabricated documents. The court has now, and a lot of cases of revocation. Courts of Pandora's box open, number of revocation petitions after probate is granted. Somebody comes knocking to the doors of court and say, this grant has been taken by fraud. I have not been put on notice. So then slowly what the court said was, please implead persons who are entitled to the property but for the will. This was the first customary practice which changed in the Madras High Court after I started practicing in the High Court. Originally, OP ordered, just paper, judge will not even see, all formalities complied, probate granted, letters of administration granted, paper publication made, LA granted. But now they said you implead all respondents. Then notice did not go to all respondents. We used to file consent affidavits. All respondents consent affidavits filed, probate granted, letters of administration granted. And somebody comes and says, no, my consent affidavit is forged. I never gave this consent affidavit. Then the question of going into the veracity of the genuineness of consent affidavit, indirectly suspecting the genuineness of the will also. The person who plays fraud by not putting on notice one of the legal heirs may in fact even create a will and defeat the original intention of the testator. He may have even desired to die without a will. Therefore, he may have created and got. Therefore, the court said, ensure that all respondents are served personally. So this is the next procedural change we saw, the original side. So first we used to show no respondents, OP was allowed. Then now impleading respondents. Now all respondents served. That is not enough. You have to come to the box and give evidence. And we have to examine the proponder and one of the attesting witnesses to show that the will was actually written while the testator was in a sound and disposing state of mind, memory, and understanding. Only then the will is said to be duly executed. The only person who can speak about that is the attesting witness. Even the beneficiary may not be around. He may have been there, he may not have been there. Executor may have been there, may not have been there. He may not have witnessed execution. Therefore, the only competent person is one of the attesting witnesses. What all he has to say is, get into the witness box and say that he is acquainted with the testator. You can't attest the will of a stranger. So he knows the testator. He may be a friend, neighbor, colleague, teacher, student, college mate, friend, family, relative, distant relative, anybody, but well acquainted with the testator. He saw him execute the will. While executing the will, testator was in sound and disposing state of mind, memory, and understanding. And when he attested the will, the testator and the attesting witness were present. This is a normal execution. The exception which we already saw was the other attesting witness comes later. He will not see the attesting witness sign or the testator execute the will. That is an exception which section 63 permits. But when you file the petition, you must be very careful. You must plead, because we normally copy the format for probate and letters administration is available in the original site. When affidavit or attesting witness cut and paste problem, we will face problem. Therefore, you must not cut and paste in such cases. You must be careful. You must clearly modify the affidavit of attesting witness and say that the will was attested in the presence of only one attesting witness, and thereafter the second attesting witness, and in the direction of the testator, signed as a second attesting witness. Thereby, due execution is proved. So you will have to be very careful while drafting the affidavit of attesting witness. Therefore, this is what the attesting witness has to speak. If there is no contest, no problem. The due execution court is going to be satisfied. Interestingly, there might be cases where both the attesting witnesses are not alive. This is quite common, because wills may have been written 15 years back, 20 years back. And it has the attesting witnesses may also die along with the testator or before him also, for that matter. And when the time it is probated, he may not be alive. So what is the procedure? Here there is a common mistake which a lot of people commit, is they examine a third party. Propounder is examined, a third party is examined. He just gives an affidavit saying that I know about the execution, I saw him. He may not be a person actually present. That is not the requirement. The requirement of section 68 of the Evidence Act is, in the case of will, if person attesting the will is also not alive, the procedure you have to follow is you will have to first prove the signature of the testator. How? Either one of the legal heirs, his father, mother, his son, daughter, or neighbor, or colleague, somebody must come and verify the signature, identify signature of the testator, because both the witnesses are not alive. That is one part. The second part is you will have to prove and identify the signature of one of the attesting witnesses. This part is missed by most lawyers. So this part is very important. If you are actually going to prove a will, you not only the signature of the testator, but also the signature of one of the attesting witnesses. So recently, I didn't have anybody in India to prove the signature of the attesting witness. He was a chartered accountant. So I summoned his partner, who is person well acquainted with the signature of the attesting witness. He came to court and he testified, saying that he cannot speak anything about the will. He will only see the signature of the attesting witness and say, yes, this is my partner's signature. I know him. I'm a partner in his law firm, chartered accountant firm. This satisfies the requirement of law. But this is very important, and which a lot of people don't know. Yet another aspect where we miss is, a lot of questions arise, is can an executor be an attesting witness? There is no bar. An executor can be an attesting witness. Can an executor be a beneficiary? There is no bar. Under section 141, an executor can be a legatee under the will. There is no bar. But what all section says is, I must manifest my intention that I am taking steps to probate the will. If I want to take benefit under the will, if I am an attesting witness, I must show to the court that I have taken bona fide steps to probate the will. So I may be only one of the beneficiaries. I may be the beneficiary of the entire estate also. Your father may write a will and make me the executor and giving the entire property to me. But still, I must manifest my intention under mandate of section 141. Only then court can proceed and grant me the probate. Similarly, who is to be the executor and attesting witness? Very simple tips I can give you is, see, there are people who write the will post 60s or 70s. They don't write a will when they are in their 30s or 40s. Very, very rare for people in the 30s or 40s to write a will. Person who has lived his full age, he would choose to write a will. During those times, he will normally call his friends who are of equal age, if not older than him, to attest a will. It's a very bad practice, because the will must survive the testator and the witnesses should be alive to speak about the due execution. So therefore, advise the attesting witnesses should be young persons known to the testator. So somebody acquainted with the uncle, son, or nephew, niece, somebody, or junior colleague. So these very important factor which choice of attesting witnesses. Person whom you trust, because witnesses can be bought over. We have seen cases where Witnesses turn hostile in will cases. Property is huge, estate is huge. There's bargaining, horse trading for the witnesses. So therefore, like choosing the executor, it is very important for the testator to choose very trusted witnesses. There can be 4 witnesses, there can be 3 witnesses, there can be 5 witnesses. There is no bar. At least 2 witnesses is what the requirement of section 63 is. Then whether the executor can be an attesting witness, yes, there is no bar. He can be a beneficiary, he can be an attesting witness. Whether a beneficiary can be, leave alone executor. Suppose there is no executor appointed under the will. Question arises whether a beneficiary can be an attesting witness. Section 67 of the Indian Succession Act is very, very interesting. See, there is a Schedule 3 to Section 57 of the Act. That schedule sets out several sections which are applicable to Hindus, Buddhists, Jains. Other sections are applicable only to Indian Christians and Parsis. Therefore, Section 67, interestingly, is applicable only to Indian Christians and Parsis. So a Hindu legatee or a beneficiary can be an attesting witness. There is no bar. If you want to apply Section 67, let's assume a Christian writes a will in favor of his wife. Probably say, let us assume a part of his property is given to his wife, remaining part is given to his children. The 67 prohibits the wife from taking benefit under the will because she is an attesting witness. So she loses her legacy because she happens to attest the will. This is the mandate of 67. But this is not applicable to Hindus, Jains, and Buddhists. But for removing any suspicion which may arise, it is always better that the beneficiary is not an attesting witness. There is no legal bar, but it is advisable that the beneficiary is not an attesting witness for simple reason that tomorrow the person who challenges the will may say the beneficiary took an active part. He is the executor. He is one of the attesting witnesses. Therefore, better to avoid. But again, the practical problem is you appoint a neutral person as an executor. See, he has his own job. Those days it was right. You know evidence. You just sign papers. Petition is filed. Probate is done. Today it is not like that. He has to come to court, give evidence, prove the will, face any very unfavorable questions, from unchaste questions from the defendants. For no sin of his, somebody wrote a will, he is being grilled in the witness box. So these are flip side of naming an executor who is not a beneficiary. Therefore, it is always better to give one of the beneficiaries the status of executor. So for 2 reasons. One, he will have interest to probate the will because he is a beneficiary. But this cannot be done where it's a Christian will. I am limiting this thought process only to Hindu wills. You can have a person who is a beneficiary to be the executor, not attesting witness, executor, or an attesting witness if it is a Hindu will. And that person has interest in the estate. Therefore, he will take active steps to probate. This is one primary reason. And you are not, secondly, is you are not going to bother some third party, asking him to file a petition, give paper publication, come to court, etc. Now, coming to the procedure, we file as I said, probate, there is a format which we follow. Letters administration with will, there is a format. Without will, there is a format. Succession certificate is a format. Forms are available in the Indian Succession Act. You just follow the template, fill in the blanks, file a petition. Now, the requirement is name the respondents who, but for the will get a right in the property. Suppose one son is disinherited totally. I must make him a respondent, serve him with notice. He is entitled to challenge. When is he entitled to challenge? He receives notice, puts in his pocket, does not come to court. He cannot later on say, I dispute the will. What he must do is he must be proactive. He must lodge a caveat. A caveat is similar to what we know under the CPC. There is also a procedure for caveat in the original side rules and also the Indian Succession Act. A person who wants to dispute or challenge the will, he can file a caveat. And the next requirement is within 8 days from the date of lodging of the caveat, he has to file a supporting affidavit. Why he is objecting to the grant of probate. So mere filing of caveat is not sufficient. You can do it both together. Both the caveat and affidavit objections can be filed together, no problem. If you file it within 8 days, no problem. Suppose you don't file it, you forget to file an affidavit objections, then only your caveat is alive. You are not entitled to challenge the will. So twin requirement of caveat and affidavit of objections within 8 days is mandatory. Interestingly, I did one case where the affidavit of objections was not filed within 8 days. So I advised my client to file a fresh KVA along with an objection affidavit. This was taken note of by the other side, defendant. He said, no, you can't do it. You lost your right. He came up before Justice Ram Subramanian. He said, no embargo under this act. You can file any number of KVAs. And as long as the grant is not made. So suppose it may be in a parted stage, advanced parted stage. There's already a suit, somebody is contesting the will. I may still file a caveat and an objection affidavit. I will be cited as a defendant. So the petitioner in the OP becomes the plaintiff. The caveator becomes the defendant. Now, interestingly, what a lot of confusion in the cost cycle we see every day is we get confused. Caveator alone will be the defendant. There may be 7 respondents in the OP. 2 of them given consent. 4 of them notice served, keeping quiet, cat on the wall. 1 of them files a caveat. 6 of them will be left out. It is only between the plaintiff and the sole defendant. The sole defendant is the caveator. Therefore, the caveator will have a right to, provided he satisfies the caveat part and objection part, it will become a suit, and court fee is payable, like how we value suits in the High Court. So additionally, court fee is paid apart from what you pay as probate duty originally. He files a written statement. I will have to prove the will in the presence of the caveator. This is where the suspicious circumstances come into play. In my written statement, as a defendant, I would raise any number of suspicious circumstances. I might question the genuineness of the signature. I might question the feeble mind of the testator. I might put forth contentions of undue influence, coercion, fraud. So any kind of, I can put forth another will. I can say, no, this is not the last will. My will is the last will and testament. These are possible circumstances under which a will can be challenged. Only I am listed only a few. There may be very many. Even courts have held normal. See, purpose you write a will is to disrupt the normal line of succession. Just because I don't give my son or my daughter some share in the property doesn't mean it is unnatural. Purpose I am writing a will is not to give him. Therefore, that court has to keep in mind. But that will not be a suspicious circumstance by itself. Merely because I am not giving a class 1 legal heir or totally disinheriting him under the will not be a suspicious circumstance. But it is one of the factors, because courts have also said it is one of the factors, because will need not be registered. There is chances that there is foul play. So what is important is see whether there is reasons. That is why ideally suggest the testator to give reasons why he is not giving somebody, or reasons why he is giving somebody over somebody, choosing somebody over somebody else. Tomorrow it will help when the will is going to be contested, if contested. Otherwise, it's not necessary that you must give reasons. Always better to give reasons. Then let us say the will can be given, and in one other interesting point is will can be made even by a person of unsound mind. But when he is during the period when he is of sound mind. So if you are able to prove that a person is of sound mind, sometimes he is of unsound mind, that person also is capable of writing a will. Otherwise, he must be a major. A minor cannot execute a will. Person, a major of sound mind, normally of unsound mind during period of lunacy or soundness can execute a will. It's valid. Provided burden of proof will be very heavy on the propounder. So this is coming back to suspicious circumstances. So defendant is going to raise number of suspicious circumstances. So what the courts have now evolved is, under section 68, you prove that 63 has been complied with, Evidence Act. Examine one of the attesting witnesses. Will was executed, sound and disposing state of mind. That is the initial burden on the propounder of the executor. Then the burden shifts. Burden shifts to the caveator or the defendant to prove the suspicious circumstance. Initial burden is always on the propounder. I must dispel or clear all cloud of doubt cast or suspicion cast on the genuineness of the will. Once I do that, burden shifts to the caveator defendant. Where forgery or undue influence plea is taken, burden is on the caveator. The fundamentals of Evidence Act. If I take a plea of forgery, it is my duty to prove that it is a forgery. If I show that there is a subsequent will, I can't just file a written statement and say, my father wrote a subsequent will next year without producing it. I must be in a position to show that there is a subsequent will validly executed, which supersedes the will in question before the court. These are ways in which the will can be challenged. Normal trial will go and suit will be either decreed or dismissed. So courts have, even though due execution is approved, if the execution of the will is surrounded by suspicious circumstances, then go slow. Don't grant probate, don't grant administration, doubt the will. That is what the courts have held. There is no straitjacket formula for what is a suspicious circumstance. It will depend from case to case. I may be able to prove that the person testator was of feeble mind, or he was unduly influenced by one of his daughters. He was taken to his daughter's house for 1 week prior to his death, during which time the will was made. He had love and affection for the son also. The circumstances, evidence I can lead and show that there is no suspicion cause. But courts have again said mere due execution of will is not enough. If suspicious circumstances arise, here again the important thing is suspicious circumstances surrounding the execution of the will, not something which happened before, or much after the demise of the testator. I see a lot of written statements where suspicion is starting only after the death of the testator. That is not enough. That's not going to take the defendant caveator anywhere. He will have to show suspicious circumstances surrounding execution of the will. During the time of execution, there was suspicion. There was some foul play, something fishy. That if you're able to establish, you can make out a case and get the TOS dismissed. Coming to court fees. Originally, it was very prohibitive to file probate. People preferred doing settlement deeds because that was cheaper than probate. Originally, it was 10,000, settlement deeds, then it became 25,000. Whereas probates, we used to pay 3% of the due estate value, market value of the estate. So it was very prohibitive cost of probating. So people avoided probate. They used to instead execute settlement deeds. The disadvantage of settlement deeds is I divest myself of the right to sell the property during my lifetime. I lose control, I lose title, I lose all interest, except for limited rights, which I've already seen. So that is, probate was more expensive. Cumbersome process, coming to court, showing everybody, citing everybody as respondents, serving them, and then paper publication in case of letters of administration. Probate, there is no mandatory paper publication. The reason being, the testator himself places confidence in the executor, X, Y, or Z, and appoints him as executor to carry out his wishes. Therefore, the court takes it lightly. The dead person himself has named somebody, so why should I take the burden? But in letters of administration, it is the beneficiary who approaches the court. Therefore, paper publication inviting objections. In one Tamil daily and one English daily, objections are invited. And in the objections, as I said, caveat can be filed anytime before the grant. Once the grant is made, you cannot lodge a caveat. But there is a backup remedy. Suppose you never knew about the proceedings, fraud plate. The testator, the propounder shows up a case as if you have been served with notice in the OP. But in fact, you have never been served. You are not residing in that address. Or for rather, he has given paper publication or reserving, trying, attempting a wrong address. You come to know after the grant, what is my remedy? You are not remediless. Section 263 provides for revocation for just cause. Revocation or annulment for just cause is under section 263. It sets out 5 instances. Courts have again said it is only illustratory, not exhaustive. The 5 instances where it will become inoperative, or it is obtained by fraud, grant is obtained by fraud, or not giving notices to parties, or it has become inoperative or useless because of subsequent will. These are factors, or for failure to file inventory and accounts. All these are grounds for revocation of probate after the grant. But here again, the problem is if you have been cited as a party and you have been properly served with notice and you don't approach the court within the time, file a caveat and objection, sleep over the matter, then you are not entitled to revocation. The just cause. The just cause has been dealt with by a number of cases by this court as well as the Honorable Supreme Court. What is just cause? Suppose there is a subsequent will, it is a just cause. Suppose the caveator is able to prove that there is fraud, it is a just cause. So prima facie proof has to be adduced by the person approaching for revocation. Either he must show that there is another will, or he must show that during that day, testator was not in Chennai, he was in Bombay. There is no possibility for him to have written the will in Chennai. We are able to prima facie show. Again, the problem which arose before the courts was, should we try such revocation applications like a suit? This was an issue which the courts were faced with. Then the court said, no, it's up to Supreme Court. It's only an application. You find out whether a prima facie case has been made out for annulment of just cause. Then convert the OP as a TOS, a testamentary original suit, where the petitioner becomes a plaintiff, KVTR becomes a defendant. Here the person seeking revocation will become the defendant. And the will have to be proved in his presence, even though it has been proved earlier to the satisfaction of the court. Because of suppression of fact or some fraud played by the propounder, Section 263 is still available. But if he was properly served, if the propounder is able to show the person seeking revocation has been already served with notice, he is engaged an advocate also, but never filed caveat and objections, he has lost his right. Otherwise, he will not lose his right to seek revocation. Then limitation. Yet another interesting question. There is limitation for probate. The Madras view is no limitation for grant of probate because there is no declaration, is only a right, continuing right. So you are only declaring your right as an executor. When I come for probate or letters of administration, there is no limitation in what the Madras view. But 2008, the Supreme Court took a different view, saying that Article 137 of the Limitation Act will apply. But even in that judgment, there is enough material to call out a proposition that if it is filed beyond 3 years, we can still get over limitation. Therefore, that the Supreme Court judgment was again taken up by this Honorable Court, Division Bench of our Honorable High Court, first bench, said that will not apply to the Madras High Court where we are governed by the original site rules. The original site rules only requires reasons to be adduced if the petition is filed beyond 3 years. If I give reasons in my petition why I have not filed the OP for grant within 3 years, that is enough. Therefore, Article 137 will not come into play. So despite the Honorable Supreme Court laying down the law, saying that Article 137 will apply, the Madras High Court has given a pronouncement where I think it is Justice Kaul and Justice Pushpa Satyanarayana. They have said, no, it is only Madras High Court rules which will prevail. So therefore, you will have to give reasons why you have not approached the court within 3 years from the date of demise. Then we have the concept of codicil. What is a codicil? Codicil is like an attachment or an annexure, add-on document to the will. If there are not very major changes, let us assume I had named X as the executor. X dies when I am alive. So I would like to change the name of the executor to Y. That is the only change I want to make under the will. I need not rewrite the will. I only execute a codicil and say that in view of so-and-so X predeceasing me, I am appointing Y. All other respects, the will hold good. Like a will, codicil also requires to be attested to at least 2 witnesses. Same requirement for will has to be followed for a codicil also. Therefore, when you go for probate or letters of administration, you will have to seek the grant will read with along with the codicil dated so and so. Only then your will is complete. So very minor changes. You have already made a bequest, or that person dies, or you want to say give 50%. Minor changes, you can write a codicil. If the major change, advisable to write a fresh will, give reasons. Here again, the interesting is one case where one mother gives the property to 2 sons in 1969. Daughters came to me with 2011 will, where she gives one property to 2 sons, the other property to 5 daughters equally. So we filed for probate of the subsequent will. The sons filed probate for letters of administration of the earlier will. Both were tried together. In the second will, there is no mention about the first will. 1969 will, there was no mention. So this was raised as a very serious suspicious circumstance, which fortunately the Supreme Court judgment saying that it's not necessary that I should mention about the previous. There may be a general statement that I revoke all my earlier wills and codicils. Some we will find in some wills, but even that was lacking in my second will. Now, mother, as if she had not written any will for the first time, she writes in 2011 after close to 30 years, more than 30 years. She says, I bequeath my property, one property to 2 sons. So she modifies the earlier will where she gave both the properties to 2 sons, totally disinheriting the daughters. She made a change, another will. It was both the registered wills, and we were able to succeed, showing that this is a subsequent will. We were able to prove the subsequent will by examining the attesting witness, who has to naturally withstand the cross-examination rituals. If you're able to satisfy the conscience of the court, then you are going to get probate. Again, classic judgments of our High Court, this is Jeshma Babu, where he said, which court of probate is not a court of suspicion. Don't start with suspicion. Don't suspect the will from the beginning. Think that it's a genuine will. See, here again, interesting, which I think aloud a number of times when I do will cases. You are doubting the will. But number of cases where the court reads the will and gives importance to the will itself. See, I am saying the blank paper my father had signed. Anything can be written in the will later. It can be converted into a will. So can you, in such cases, give importance or take cognizance of what is written as reasons to disinherit me in the will? So therefore, you have to see what is the nature of defense. It is some flimsy reason caveat is filed, or not seriously objecting the genuineness of signature or the soundness or disposing state of mind of the testator, then there is no harm in going through the contents of the will. It again boils down to the proof which you are going to adduce, the circumstances. The witness has to speak very clearly about the soundness of the testator at the time of, he may have become paralyzed much later. On the date of execution, was it suspicious or not? Was it due execution? Did it comply with the law? That is sufficient to dispel the burden. So therefore, revocation. And now the Supreme Court, again, in Leonard Fernandez case, said Article 137 will apply to revocation petitions also. So where normally you come within 3 years, it can be from the date of grant, or it can be from the date of getting knowledge of the grant. These are most common scenarios where a person can seek revocation. I never knew about the grant. I came to know only in 2020 January. So I will have time till 2023 December end. Or date of grant within 3 years, no difficulty. But the Supreme Court said 3 years, Article 137 will also apply to revocation petitions. But applying what the division bench said, we can safely say that for Madras High Court, the position is different. But revocation position may not be different, because reasons required is the only factor in the original side rules for the delay, which went into the decision of the Honorable Division Bench to differentiate and distinguish the Supreme Court judgment. So therefore, Article 137 for revocation will apply, provided when cause of action arises. That you will have to decide. You will have to prove to the court when the cause of action arises, you are within 3 years from the date of cause of action accruing to you. The codicil limitation will apply. Therefore, revocation will apply. I think most of it is covered. If you have anything.
So there are a few questions that have been posted in the chat box. If we can move on to the Q&A session.
Sure.
So if any participant has any questions for the speaker, they can post it in the chat box, and I will read it out to the speaker for him to address it to you. Suresh sir had asked one question. He asked, if the executor is not ready to continue or dies after filing the probate, what will be the status of the will? I understand that you had mentioned the situation as to what will happen after he dies.
Correct. Even if he is not willing, you can make an application before the master and ask him to demit office. Then you go ahead with the letters of administration. Suppose the will may be in the custody of the executor. So you file an application asking him to produce the original will.
Right.
And renounce his executorship. You can make an application to the court and proceed.
Mr. VPR Menon has a question. As the settlement deed with provision for later revocation shall be treated as a will it be necessary to probate such a settlement deed?
If it is a will, it has to be probated. You may call it nomenclature, maybe a settlement deed. If tomorrow your lawyer finds that though styled as a settlement deed, it is only a will, you definitely have to probate. If it falls within the 3 chartered high courts.
Moving on to the next question, Mr. Vaidyanathan has a question. Actually, the probation of will has been introduced by the British rule only in the presidency towns, intended to collect taxes. But since it is not necessary to probate the will to the rest of the presidency towns and villages in India, since such practice in probating wills even after the Constitution of India.
Discrimination, yes, is a very interesting aspect which I will briefly say. See, originally under Section 213, Muslims were exempted from seeking probate and letters of administration. Then Act 26 of 2002 the act was amended. Christians were also exempted. So therefore now the onus is only on Hindus, Buddhists, Jains to probate wills. even Muslims and Christians are now exempted under Section 213. The Planning Commission did find this to be discrimination, and they have recommended amendment to Section 213 or totally scrap 213. See, you have a remedy. Suppose there's a forged will, you can always challenge it in a partition suit also. See, like how it happens now today in sub, let us assume a case in Shengalpet. The will does not require probate. The defendant sets up a will and says that there is no right for partition to my sister. There is a will in my favor. That will need not be probated. But that will can be challenged in a partition suit. The sister can still disprove that the will is not genuine and get her partition suit decreed. Therefore, Planning Commission has already, Law Commission has suggested that they either amend 213 or do away with 213. Definitely, I agree totally with you. It is a discrimination. Today, in a Hindu country, only Hindus are required to probate or seek for letters administration.
Moving on to the next question, Advocate Innisai is asking, what is the status of a will without mentioning the schedule of a property?
So there is no, as I told you earlier, there is no specific form like a settlement deed where a schedule is mandatory. There is no necessity that I must incorporate a schedule in my will. If I am having enough info, I must identify my property. I must say I have a property in Tinagar, that is enough. If I do not have any other property, no problem. If I have two properties, if I say I have one property, then it becomes a problem. So therefore, no necessity to complicate the will by including a schedule. Suppose there is a mistake in the schedule. You can't rectify the will. That is the biggest problem we face. I have come across cases where there is incorrect description of the property in the schedule, but we are stuck with it. The person who writes the will is no more. I can't go and amend the will or amend the schedule. Therefore, better to make it as simple as possible. Don't complicate.
Mr. V. Vasantakumar has asked, insofar as original side is concerned, once caveat is filed, the OP is converted to TOS and petitioner would be directed to pay court fee, but the Mofussil court is not following such procedure. Kindly elucidate the reasons for disparity.
They have to, sir. Even the Indian Succession, not only original settlement, even the Indian Succession Act contemplates the procedure of person who is entitled to defend. Definitely, I don't see them converting as a TOS, but at least they conduct trial and decree the OP, decree or dismiss the OP. But actual procedures, you must convert it as a suit. There are the provisions available in the Indian Succession Act for a district court also.
Mr. Raghvendran has asked, joint will is executed by two persons, that is father and mother, about the properties in their name. After execution, one person expires and another person survives. Who cancels the joint will for the property owned by her or him and executes a fresh settlement for the said property? Is it maintainable?
Yes, I already discussed this. It is possible as long as the survivor not taking benefit under the deceased testator. Suppose I take some benefit under my husband's property, then I am not entitled to cancel. If suppose I don't take any benefit, then I can cancel, write a fresh will for my property. It is permissible.
Mr. Sanjay Pinto has asked, would an advance directive for medical treatment in the form of a power of attorney document suffice in terms of Section 5 of the Mental Health Care Act 2017?
Yeah, again, the issue is at large in India. It says any document or declaration. So not necessarily that should be in the form. It can be a power of attorney also, because it basically vests the power of deciding what should be done to you, what treatment should be given to you in some person in whom you place trust. It may be your family member, friend, anybody, colleague. So therefore, I don't see any reason straight away to say it can't be done by a power of attorney. But again, we'll have to see what the courts are going to. The only directives which broadly set out how a living will should be gone about. But I don't see many living wills actually being made, because the procedure is very, very complicated.
The next question is from Mr. Peranban. Whether failure to filing caveat and objections affidavit is a bar to cross the witness or mandate necessary application.
You see, when you're reading evidence, definitely you can cross-examine, even though you have not filed a caveat. So courts do permit cross-examination, even though you have not filed a caveat or an affidavit of objections. Courts do permit, but ultimately it's going to weigh down the defense. Your right, your available right is not availed of. So whatever cross, unless you are going to show the court that there is absolute fraud committed, you are able to, because even otherwise court can see through the fraud played. Therefore, it is only aiding the court. The cross-examination is not about, it can be allowed, permitted.
Another question from Suresh sir is that after converting POS, is the plaintiff entitled to file a plaint or rejoinder for fresh pleadings?
Yes, he can file after the written statement. He can file. See, suppose what I'll tell you the difficulty. There is a format, practical problems all advocates face who come to court for probate or letters administration. There is a form which we follow. You are not expected to anticipate somebody to come and object. And you do not know on what grounds he is going to object. So you're not given a reason for saying all that upfront. You can do it only after the defense is taken or a caveat or objection is filed. Therefore, necessarily, you have to file a rejoinder to the written statement and dispel all suspicious circumstances. Even though not necessary, I would suggest do it in all cases. So your petition will contain nothing. It will just contain so and so respondent, he executed the will in presence of witnesses whose affidavit is filed. I undertake to file inventory accounts within 6 months to 1 year. Grant me probate. Nothing else will be there in the petition. It's a very skeleton format which we follow.
So Prashant Rajagopal has two questions. First one is that, can I apply for probate of a will in an official court, even if probate is not mandated?
Yes, you're jolly well. No bar. District court can be approached seeking probate, even though it is not compulsory.
The second is, will reserving life interest for me and my wife while executing settlement deed in favor of my son, will reserving life interest for me and my wife while executing settlement deed in favor of my son, note not right to reside or receive rent but life interest in the property?
I don't understand the question. See, life interest word is it's very too wide. So what better, as I said, is use the phraseology right of residence, right to collect income. So you can still call it life interest, but if you are going to keep the right to alienate unto yourself later on in the document, then it's going to become a will. So therefore, better, even though life interest is not impermissible, avoid the terminology, phraseology, the term life interest, and use the right of residence and or right to rental income. That would carry more meaning to what you want.
The last question
Prashant has come back.
from
I meant if I can use the word life interest. I think I clarified that even before he asked. No harm in using, but will be read as a whole. Another important feature is, suppose there is discrepancy from the earlier part and later part in a will. Like any other register, unlike any other registered document, suppose the sale deed, there is a discrepancy. Total contradiction, the first page and the third page. What is stated in the first page will prevail. But whereas in a will, what you have stated subsequently will prevail. Because that is my last intention. I may have given to Ashok Pati upfront, but later on I have said, no, I don't want to give to Ashok Pati, I am giving it to Ritika. So therefore, this is last part of the will prevail, unlike a sale deed or a settlement deed.
We'll take the last two questions for the day, one from Mr. Raghavendra and another from Mr. Sanjay Pinto. Mr. Raghavendra has asked if the beneficiary under will is not informed about the will, whether the later beneficiary can seek probate or entitle for properties under the will.
Yes. See, there is a provision where you can take a limited grant. See, originally, especially where you have to pay a huge court fee, it's not necessary that I must pay a court fee for somebody else. He is not interested to probate. I can ask for grant in my favor insofar as it bequests in my favor. I need not probate the entire will. Then later on, he can come and say, this part give me probate. There's no bar, it can be done.
The next question is from Mr. Sanjay Pinto. A will written by a lay person can be interpreted in multiple ways. How is such a situation resolved?
No, that is why I said it is for the court. Sit in the armchair of the testator, read the will as a whole. Will the testator would have acted in such a manner in such circumstances? Privy Council, in fact, had an occasion to see a will where entire property was given to a fiancée. Not even married. He was proposing to marry that lady. Entire property is given to her, disinheriting his father, mother, everybody, blood relations. The Privy Council said, bequest may be foolish, and man may act foolishly and give what it is only his, as long as his wish is genuine. His wish to give to his fiancée is proved. His act may be foolish, but still you give respect to his wish, his last intention. That must be respected because that is his solemn wish. So therefore, this is the position.
Thank you, sir. That seems to be the end of the Q&A session.
Ashok has asked some question. I was able to see. Registry is insisting on production of title deeds. Yes, off lately, yes. Unfortunately, yes, we have. I think we have made it onto ourselves, complicating this because number of litigants are abusing the process of law, and as advocates, sometimes we fall prey to their mischief. There are wills are written for property not belonging to you. So courts have come across such instances. Now therefore one judge, while seeing that matter, he has said, hereafter ask the parties to file proof that his testator owned the property. So a photostat copy is sufficient. But you must prove that prima facie the subject matter of the will property belongs to the testator. You can't write will for your father's property. So therefore, you prove that it is your property, so that it can be bequeathed validly under your will. So prima facie, they want proof. So it is a procedure invited by ourselves, is what I would say. Unfortunately, very sad.
Thank you, sir. So now I request Mr. Kamleshwar to render the vote of thanks.
Last one, okay, to the third party, yes, very much. Will can be to a man on the streets. Tom, Dick, and Harry can be the beneficiary. Not necessarily it should be legal heirs.
Yes, sir. Kamleshwar would continue the vote. Thanks.
Respected Speaker, members of Study Circle, and members of the legal fraternity, on behalf of the Study Circle team, it's my privilege to propose the vote of thanks on this occasion. I take this opportunity to thank our speaker, Mr. P.B. Balaji, sir, for enlightening us on the subject of will, especially with respect to the types of wills, when a will should be written, the difference between will and a settlement, annulment of will, revocation, and limitation. I once again thank Mr. P.B. Balaji, sir, for taking his valuable time and spending it with the Study Circle family. I thank all the participants, the members of Study Circle, and the organizing team of Study Circle for making this 98th webinar a successful event. I would like to conclude with a quote. Knowledge has a beginning, but no end. And thank you all once again for joining this knowledge sharing session. Thank you.
Thank you.